Defamation and privacy is a legal issue that has origins in English common law. During the English common law era, defamation was punished both through the law of equity. In the United States, defamation, as for the most part, is not a criminal offense. However, a person can be liable for damages towards the reputation of another. The good news for anyone wishing to publish materials about such as a person as a politician or government official has a lot of guaranteed protection under the Constitution. New York Times versus Sullivan, a Supreme Court case, addressed that very issue when a person or a group published an article in the New York Times criticizing the government. According to Justice William Benham Jr., he stated in his opinion that the debate against public officials should be wide open and that the constitutional protections did not depend on the truthfulness of the publication. Thus, actual malice would be the level of proof to win in a libel case by a public figure. Hustler magazine published a liquor ad portraying a prodigy of Jerry Falwell, who is a Virginia pastor. Jerry Falwell, being a political figure or a public figure, sued the magazine, stating that the fictional ad damaged him through invasion of privacy, libel, and infliction of emotional distress. The Supreme Court granted certiorari and decided that a reasonable person could not have believed the prodigy to be a depiction of an actual interview. In the Illinois laws, the Illinois Constitution has provisions protecting individuals' privacy in relation to government search and seizure of property. In addition, there are laws regarding trespass and unauthorized videotaping and eavesdropping. People cannot go in and videotape private areas such as bathrooms, private homes, tanning salons, and locker rooms. These violations are often misdemeanors, and the Illinois Eavesdropping Act makes it a felony to audio record a conversation either by electronic, unless there's consent by all parties on the recording. The Scopes Monkey trial was the first O.J. Simpson courtroom-style drama stunt show in American history. The trial argued the constitutionality of the Tennessee law that prohibits teaching of evolution in school. The case went into limbo and never reached the Supreme Court. The ACLU wanted the court to hear the Tennessee law rule to be unconstitutional, and it basically argued that the Charles Darwin theory of evolution versus the doctrine of creation, as written in the Christian Bible, to go beyond the scope of what the Constitution allows, thus making a violation of constitutional law. The education debate between evolution and creation is still a red button topic today, and many American school systems still are dealing with that very same discussion. The Children's Internet Protection Act provided protection to minors under the age of 18 against being exposed to sexually explicit material on the Internet. Reno versus ACLU in 97 argues the issue of this constitutionality of indecent and offensive behavior that is exposed to minors. Roth versus the United States in 57 establishes obscenity of a substance of a sexual content to have no redeeming or social value. Any image, either real or animated, that is sexual and portrays a person under the age of 18 is not constitutionally protected, thus can be criminalized. The FCC also has the authority to regulate indecency on the airwaves, either by publicly aired or by radio broadcasts. This does not cover satellite broadcasts such as satellite television or XM radio. Reno versus ACLU was an issue about protection of minors concerning an issue of indecent material of a sexual nature content over the Internet. The case was argued that the minors can access the pornography site and view sexually explicit material. The court concluded that the websites use protective measures such as passwords or warnings, and that the user needs to take affirmative steps in accessing the material. As a result, internet pornography is considered constitutionally protected speech. On the issue of college expression, the safeguard of free speech among public campuses and universities is of vital importance towards higher learning. If the learning environment in public universities become restricted, there will come a slew of issues that will result in citizens narrowing their advantage of freedom and tolerance. Free speech restrictions will result in tolerance, censorship, and criminalizing freedom. The benefit of learning about arguments in an academic environment or a college environment will quickly diminish. Hazelwood versus the United States, the court concluded the students in a public school do not shed their constitutional rights to freedom of speech or expression at the school gate, and they cannot be punished merely for expressing their personal views on school premises, whether in a cafeteria, on the playing field, or campus during authorized hours, unless school authorities have reason to believe that such expression would substantially interfere with the work of the school and impinge on the rights of other students. The choice on same-sex marriage in the case Perry versus Schwarzenegger regarding Proposition 8, basically the statement is Proposition 8 violates the plaintiff's equal protection and due process rights, and that the court presumes harm where the plaintiff has shown violation of the constitutional right. The 14th Amendment guarantees protection under the law to include all race and gender. It would be difficult to predict if the Supreme Court will hear the case, but if heard, it will be a split vote, and Justice Kennedy will be the swing vote. If the Supreme Court refuses to hear the case, then it would be up to the states to decide on issues of same-sex marriage. If the court hears a case, it would be more likely than not that the prohibition of same-sex unions will violate the Equal Protection Clause of the Constitution. The First Amendment gives people the authority and protection to aggressively investigate government and public officials. There is no fear when a person publishes caustic or critical remarks, even with the intent to discredit or attack another person's reputation, so long there's a base of fact behind what they are saying. There is no other place in history that gives a person this much power.